Hello friends, in our series of sessions to discuss the question papers of this year's law optional. Good afternoon, Arvind. Yeah, so the next is, we have covered paper 1 in the last 2 sessions. So today we are starting with section A of paper 2. We know very well the syllabus of the entire paper 2 is law of crimes, law of torts, contract act, mercantile laws, and contemporary legal issues. Okay, so there are about 8 contemporary topics which will be covered along with the law of contract and mercantile law under section B in our next session. So today's session we are taking up law of crimes and law of torts. I have done a small analysis of the question pattern. So I found that about in this section, section A, 60% is law of crimes, 40% is law of torts in this section. And we'll find that most of the 20 marks questions, जो 20 मार्क्स के हैं जिसमें we can write up to 250 words are pertaining to law of crimes. तो थोड़ा टिल्ट है law of crimes की तरफ, of course होना ही है, because law of crimes covers larger part of the syllabus of section A of paper 2. But there's a very nice balance of questions this year. First thing is, questions are straight. Straight का मतलब you have been asked to define this, right? How to explain, particular terms are given. So the terms are there in the beginning of the question itself, then legal provisions. It is in the same manner in which I ask you to write the answers. कि पहले टर्म्स आएंगी, टर्म्स को एक्सप्लेन करेंगे. इसमें स्टेटमेंट कम है, एक केस है. ठीक है. सेकेंड पार्ट ऑफ द आंसर, लीगल प्रोविजंस. द क्वेश्चन इज ऑल्सो फ्रेम्ड लाइक दैट. एंड देन फाइनली द कंक्लूजन. अगर मांगा गया है, नहीं तो यू कैन कंक्लूड on the overall contents of your previous 2 paragraphs or earlier parts of the answer. बड़ा वही पैटर्न है. तो वही मैं बार बार ये कहता हूं कि आप इसकी मास्टरी करिए, बार बार आंसर्स लिखने की प्रैक्टिस करिए इसी पैटर्न में, और उसी पैटर्न में ही आपके क्वेश्चंस पूछे जाते हैं. दूसरा है टाइम मैनेजमेंट. मैंने थोड़ा सा इसको डिवाइड किया कि 3 hours एंड देर आर अबाउट 19 क्वेश्चंस. सो 1 minute, दैट मीन्स यू शुड, हाउ मच यू विल कवर इन 1 minute, क्योंकि हर एक क्वेश्चन के अलग अलग वर्ड लिमिट है. तो 20 वाले मार्क्स में या 250 वर्ड्स वाले में यू विल हैव टू स्पेंड लिटिल मोर टाइम. सो आई फाउंड दैट द फॉर 20 marks question you should roughly spend about 12 to 15 minutes, not more than that. Then for 15 marks question, maximum 10 minutes. और 10 marks जो 150 words का है, that's about 7.2 minutes. Very important time management. इसमें बड़ी मुश्किल हो जाती है शुरू में. If you spend more time, you are little slow, then you will face the difficulty towards the last part of the paper. But if you maintain a steady, and that comes with practice. इसमें कोई और तरीका नहीं है सिवाय आपको खुद प्रैक्टिस करने का. शुरू में आप जब आंसर लिखना शुरू करते हैं तो यू मे फाइंड के टाइम थोड़ा कुछ ज़्यादा लग रहा है. जब आप प्रैक्टिस ज्यादा करने लगेंगे और आपके कंटेंट्स दिमाग में उसी तरह फ्लो बनना शुरू हो जाएगा, तो आप ये देखेंगे कि विद इन नेक्स्ट 2 or 3 months you will be able to manage within this time limit. फिर आपको 5-10 मिनट चाहिए रिवाइज करने के भी। एक बार क्विकली क्वेश्चन अपने आंसर्स को रिवाइज करना है कि कोई चीज छूट तो नहीं गई, ठीक है। या आपको कई बार क्या होता है कि इफ यू आर स्टक विद ए क्वेश्चन, समझ नहीं आ रही, डोंट वेस्ट टाइम ऑन दैट, मूव ऑन टू द नेक्स्ट क्वेश्चन। जब बाद में टाइम मिलेगा वापस आ जाओ और उसको कंप्लीट कर दो, राइट। सो इस तरह से आपको अपनी आंसर राइटिंग प्रैक्टिस करनी है। सो लेट अस स्टार्ट विद द क्वेश्चंस ऑफ दिस सेक्शन। Section A, question number 1. Question number 1 and question number 5 you will find have got 5 parts each, A, B, C, D, E. ठीक है, 5 किस में आएगा आपका? Section B में आएगा। So in both the sections, question number 1 is of 5 questions, 10 marks each. That means maximum limit is 150 words. The questions will be straight. Particularly in this paper, you will find the questions are quite straight. So you don't have to explain too many things into that. इसको आप reduce कर सकते हो 150 words पे into a beautiful answer. Right? Now let us start with A. 1A, discuss the doctrine of transferred malaise. इसको मार्क कर लीजिए। You have to explain this. Discuss का मतलब you have to explain. Next part, as applied to law relating to culpable homicide under Indian Penal Code. It is very specific. So first thing is, what is doctrine of transferred malice? Where do you find it? In the IPC. देखिए 299 is culpable homicide, 300 is culpable homicide amounting to murder, and if you see the next section 301, you will find this is there. So what is required in what is culpable homicide? Of course, for our understanding, you don't have to write it in the answer. Homicide is causing death of a human being by another human being. Culpable is which is unlawful. So culpable homicide definition is given in 299. In certain situation, it may become murder. Right? We are not going to discuss it here, but we are going to discuss 301. That means in the case of culpable homicide, what is the mens rea? Either there is an intentional causing of either death or a bodily injury likely to cause death, or knowledge. You have the knowledge that this bodily injury is likely to cause death, or the act is so dangerous, right, which is likely to cause death. Knowledge. So either intention or knowledge. So when we talk about intention, it is intention to cause the death of a person, a particular person, right? But if somebody intends to, or has the knowledge that his act or the injury, bodily injury he is inflicting on that person is likely to cause death or is certain to cause death. There can be 2 ways. Now, if by doing his act, the final act, the stages of crime, intention, preparation, attempt, and then commission. So when he has taken the final step towards commission of the offense, here, of course, homicide. The person who is intended to be killed, he doesn't get killed. But his act causes the death of another person who is not intended. Who was not intended. जिसकी उसकी intention नहीं थी मारने की, लेकिन उसकी death हो जाती. So this is, malice is what? What do you understand by the word malice? It is ill will, not in good faith, with a bad intention. Right? So it lies here in the mind. तो जिसकी डेथ कॉज करना चाहता है उसकी बजाय दूसरे की हो जाती है, एक्ट रिमेन्स द सेम. So that means the malice has shifted from the targeted person to another person whom this fellow didn't intend to kill or cause his death. Right? So with this background, let us now start looking at the culpable homicide. It has to be culpable homicide. 301. By causing the death of a person other than the person whose death was intended. So, you can write here doctrine of transferred malice given under section 301 and write this. That is, you are doing the first part and also as applied to law relating to culpable homicide under IPC. IPC provision भी आप दे रहे हो. बट ट्रांसफर्ड मेलाइस को आपको थोड़ा सा जैसे वर्ड्स में मैंने बताया वैसे आपको एक्सप्लेन करना पड़ेगा. राइट? सो इन दिस देन यू कैन राइट अंडर सेक्शन 301 दिस इज. सो व्हाट आर द एसेंशियल. इसी को ही आप एनालाइज करके ऐसे एसेंशियल लिखेंगे. क्या है? कॉज द डेथ ऑफ ए पर्सन, ह्यूमन बीइंग. तभी तो कल homicide बनेगा. By doing an act with the intention or knowledge of causing death of a person. A person. जिसकी आपकी intention है या knowledge है. और causing, either you cause the death or causing bodily injury which could lead to death, which is likely to cause death. Now, causing the death of another person, A की जगह B, instead of the person intended. This person intended was A. Simple. Write in these simple words. घबराओ नहीं, इसमें क्या है जी बड़ी ट्रांसफर ऑफ मेलाइस, ट्रांसफर्ड मेलाइस बड़ा डिफिकल्ट लग रहा है. कहाँ है डिफिकल्ट? वेयर इट इज डिफिकल्ट? Such an easy, straightforward question, straightforward answer. Then you can give the example. It is also called, sometimes it is asked in this form. What is death by mistake? देखिए, death by mistake doesn't mean that it will be pardoned. It will not be pardoned. It is some consequence which you never intended. You intended a particular consequence, but something else happens and causes death. So जो आप करना चाहते थे उसकी बजाय कुछ और हो गया तो क्या हो गया? मिस्टेक ही हुआ. That is also covered under transferred malice. So अगर क्वेश्चन में ये पूछा जाता है इसकी बजाय transferred malice की, तो don't get confused. It is same. Then there is a case lays down that culpable homicide may be committed by causing death of a person whom the offender neither intended nor knew himself to be likely to kill. Is it clear? Right? Let's move on to, and don't have to write much. It is such a straightforward question, but only thing is this has to be defined properly in the same manner in which I have spoken, with compressing the words so that they are within 150 words. Then comes B. Discuss the nature and scope of right of private defense of property. You have to what is the right of private defense of property? And property will include both movable as well as immovable property. Property, agar mention nahi ki hui, and in IPC it is right of private defense against property, of property, right? Along with the limitations. So you don't have to just write this. There are limitations on that also. Limitations are also given in the IPC. If any, yes, there are limitations on the exercise of such rights. So first thing is you have to mention this in your first part, and then there are limitations. Then come to the provisions. 97, section 97 talks about, declares that everybody has a right to private defense of property subject to the restrictions contained in 99. उसी में ही दिया हुआ है. If you see 97, 99 reference. So it is subject to, it is not a absolute right. Right to extends to defending both movable and immovable property. Also, not only your own property, but property of any other person. This is very important to mention. Right? It is restricted, falling under the definition of theft, robbery, mischief. It is not available to an aggressor. Because right of private defense is not available to aggressor. It is the person who is facing the aggression. He gets this right. So what are the limits? Right? So you can just start this part of the answer with this. Right of private defense. In this is the landmark case. So this will come in the second part of your answer, where exercise subject to their conditions which are provided in section 99 have been highlighted in Puran Singh's case. What are those? You have to write this. No sufficient time for recourse to public authorities, and no harm more than necessary to repel the attack is caused. Right? Right of private defense is available. The general principle is it is available to a person who doesn't have recourse to public authority. उसके पास ना टाइम है या nearby there is no public authority. Then he can defend himself. Defense. The word defense comes from defending oneself, either body or property. Right? So restrictions are, if there is a public authority available, then this right will not be available. You have to take the help or report it to the public authority. Otherwise, you yourself may become aggressor. Then next is no harm more than necessary. It's a question of fact. कितनी जरूरत थी? Have you exceeded that or not? Then refer to section 103, which limits right of private defense of property to the extent of causing death to only the most gruesome of the offenses. अगर इस पे लिखना चाहें तो we can write a lot of things, but don't get tempted to exceed the word limit. If you write only this much part with little bit of expansion, explaining these three, then your answer will be taken as complete. Right? Now we come to the third one. Illustrate the doctrine of constructive criminality with reference to law on abatement. Now, friends, if you talk about doctrine of constructive liability, it covers lot many things. Section 34, common intention. करता कोई है, लेकिन लाइबिलिटी दूसरे की भी बन जाती है जिसने एक्चुअली नहीं किया, बट इट इज हिज कंस्ट्रक्टिव लाइबिलिटी. Are you getting it? Now, there are lot many other things which are covered under this doctrine of constructive liability, which are what? Common intention. 34, common object 149, 120A conspiracy, criminal conspiracy. But look at the question. It is not talking about others. And you don't have words available to you. You have to concentrate only with reference to law on abatement. Right? So that's why this question is asking a very, very concise answer, very to the point. उन्होंने point भी mention कर दिए कि don't get lost in explaining what is constructive criminality in the case of others. Concentrate on abatement. What is there? Connecting link between the main offender and the others who are constructively made liable. Main offender who actually executes. Right? When several persons take part in the commission of an offense, each one of them may contribute in some manner and degree different from the others. ये लिखना है आपको. Because this is the explanation of this doctrine. Then a person who does not himself commit a crime may, however, command, urge, encourage, induce, request, help a third person to bring it about, aid, help, or induce. By using these words, you are taking it towards abatement. And that is what is required here. 107 to 120 deals with abatement. Now, an abater, the person who is abetting another person to commit an offense, gets the liability, criminal liability. That is his constructive criminal liability. Though he is not actually doing that act. He is only instigating, inducing, aiding, helping the offender to commit that offense. But his liability becomes constructive liability. He is also liable under the law. So you have to write this. Not exactly mug up nahi kariye ye. If you remember the terms only, instigation, inducement, helping, urging, all these things will be covered under this. ठीक है, चलिए. Concentrate on this now. Intentionally aids a person or illegal omission. Act and omission are covered both under the IPC. They are taken as same. Okay. So if it is written illustrate. If you can give an illustration, A instigates B to kill C, and in consequence, C is killed by B, A is also liable for the same offense. बस इतना illustration हो गया. Plus ये जरूर लिखना है आपको. Even if you leave the first one, you cannot leave these two. भूल भी जाते हो तो ये तो जरूर याद रखना, लिखना. And then you have to write this, since it is only with reference to law on abatement. So don't venture into other parts of constructive liability. Right? If there is a question, what is illustrate or discuss the doctrine of constructive criminal criminality, and when it is applied. If it is an open question like that, then you will have to mention all. But here it is with reference to only abatement. So don't venture into other areas. Yeah. बिल्कुल जरूरी है, क्योंकि देखिए आईपीसी में there are only very few sections in your syllabus. तो उतने सेक्शन तो आपको याद रखने पड़ेंगे. जब आप लिखोगे तो प्रैक्टिस हो जाएगी. आपको एकदम दिमाग में आएगा 107 अबेटमेंट. राइट? So we come to fourth part, he who acts through another. Now, if you see, first three parts were with respect to law of crimes. Right? Now comes the question of he who acts through another does the act himself. It is a maxim also. जो वो खुद कर सकता है वो दूसरे के थ्रू करवाता है. तो आपके दिमाग में क्या आएगा? Vicarious liability immediately. And even in vicarious liability, two terms must come to your. One is agency, other is master-servant relation, superior. Respondent superior. Yes, you got the answer. Now, discuss the tortious liability entailed in the above state. So, what is the tortious liability? Arising out of tort. Now, in general, a person is responsible only for his own acts. ये लिखना है, please. But there are exceptional cases in which the law imposes on him vicarious responsibility for the acts of others. However, blameless himself. He might not have done any, might not have participated, but he engages somebody else to do that or gets this act done through somebody. Vicarious liability refers to a situation where someone is held responsible for the actions or omissions of another person. Connection between principal and agent, which is agency. What principal can do himself, he gets it done through his agent. So for the act done by the agent, principal is liable. Master and servant. So, respondent superior. Let the principal be liable, let the superior be responsible, and puts the master in the same position as if he had done the act himself. Then, act of an agent is the act of the principal. Right? Either he expressly or by implication, impliedly, authorizes some act to be done by another person who is his agent. The case is there. Agency does not mean physical control, but control over his actions. This is what we have taught in the law of torts also, written in the notes, exhaustive notes. Yes, please. You wanted to ask?
Sir,
नहीं याद आती मैक्सिम मत लिखो, गलत मत लिखना, ठीक है, लेकिन उसका मीनिंग जरूर लिख देना सिंपल वर्ड्स में. दैट विल सफाइस. गलत नहीं लिखना, अगर तुक्का नहीं लगाना, गलत नहीं लिखना. और अगर उस मैक्सिम का रियल वर्ड मीनिंग आपको पता, वो लिख दो सिंपल लैंग्वेज में. चलिए, वी कम टू द fifth part of question number 1, that is, explain the various kinds of damages that a plaintiff can claim after a tort has been committed. So, in the case of tort, what is the remedy available? Unliquidated damages, which are not predetermined. But what is here? You may start your answer with this. The examiner will be very happy that you know the differentiation between liquidated and unliquidated damages. But here, the examiner is asking is various kinds of damages. So start your answer with that, and then you have to write what are the different kinds of damages. Nominal damages, right? Exemplary damages. Special damages, right? Or prospective, which are anticipated damages arising out of a tortious act. These are few. Let's see. Nominal, equivalent to the harm suffered by plaintiff. Contemptuous, which is very small amount just to make that you have done a wrong. to realize compensatory, aggravated and exemplary damages. See, in the case of unliquidated damages, it is left to the courts to decide because parties, there are no predetermined damages. The court will decide under which category the remedy will lie, which category of damages. Prospective, future damages, general damages, special damages, where court may say, yes, this is something which requires, or yes, please. Yes, Mahesh. Yeah. Can you speak out, please? You have raised the hand, please speak out. Or you can even type if your mic is, if you have any difficulty. But I would love to answer your question or clear your doubt. Okay. हाँ, बाद में भी पूछना चाहें तो there is no problem. Let us proceed with this. Continuing damages. ऐसा एक्ट है जिसमें कॉज ऑफ एक्शन इज कॉन्टिन्यूइंग, चलता जा रहा है. ट्रेसपास, कॉन्टिन्यूइंग ट्रेसपास, खाली ही नहीं कर रहा, पोजेस बाहर ही नहीं जा रहा आपकी प्रॉपर्टी से. Every day a fresh. So this is, now we come to question 2A. Now question 2A, friends, the first part A is how many? 20 marks. That means 250 words. If you see, there is a illustration given where you have to explain that what offenses have been, if any. This is generally asked in every paper of law of crimes. एक आधी illustration का based question जरूर आता है. In 1986, when I wrote the exam, there was an illustration on offense of theft, 378 के ऊपर. They gave this illustration. And then the question was whether offense, if any, has been committed or not. So you have to be very thorough with the provision, the legal provision, particular section, offense, what are the ingredients of that offense, and then conclude. So here, this is in fact illustration. You read carefully, you will find that there is one, this, killing her, and then thereafter raped her first, and this is the second. Now you have to analyze in the light of the legal provisions of IPC and also the case laws, what offenses, if any, have been committed. 1 and 2. If any M has committed in the above case, explain the relevant statutory provisions in detail. So what is the first one? Murder. Right? Now, second part, of course, first part is clear. You should not have any difficulty in answering that. I am more worried about the second part. The question is, can anybody commit the offense of rape on a dead body by having a sexual intercourse with a dead body? Go back to the definition of rape given under 375. क्या है उसमें? Whosoever has sexual intercourse, right, which means penetration, without the consent, against the will. These are the words which have been used. Blah, blah, blah. There are other parts also. But what is the main focus here? The main focus is without consent or against her will. Now, can a dead body give consent? Can a dead body participate in the act? Can the dead body have a will and against the will the sexual intercourse has been done? This has been clarified in this judgment. Recent judgment, May 23 की judgment है कर्नाटका हाई कोर्ट की, wherein after murdering her, exactly the same. देखिए आपका जो पेपर बनता है ना जनरली जून जुलाई के आसपास बनता है, तो तब तक का उनका फोकस होता है कि लेटेस्ट डेवलपमेंट क्या हुई है लॉ में, वो आपको आती है कि नहीं. और जजेस ऑल्सो इंटरप्रेट इन कीपिंग इन व्यू द प्रोविजंस, लीगल प्रोविजंस. दे आर जस्ट इंटरप्रेटिंग द लॉ. You already know the law. Without consent, against her will, and other factors. You don't have to write all the factors. Right? Now, culpable homicide amounts to murder. Intentionally he killed. Slitting is intentional killing. It will come under 1. Clause 1. Firstly, 300 firstly. Punishable under 302. Murder. Right? It is covered, well covered under culpable homicide amounting to murder. Then sexual assault on the second part must be accomplished with the person, not a dead body. Then it must be accomplished against a person's will. Feelings, outrage to the person, feelings of the victim. A dead body has no feelings. A dead body cannot give consent. Right? So, you can see murder and then no rape. It can be yes. It's not that it would not amount to offense of rape, but sexual intercourse on a dead body is nothing but necrophilia and not a specific offense under IPC. Right? It could be brought under 297 as causing indignity to any human corpse. Corpse hota hai dead body. Your answer is complete. हो सकता है, पर abduction से ज्यादा जो है आपका murder will be. He pulls her into the bushes and slits. That is intentional killing. एबडक्शन का तो फिर आप जितना खींचना चाहो खींचते जाओ, पर मेन है आपका मर्डर, रेप. वी कम टू सेकेंड क्वेश्चन. 15 marks and 200 words maximum. Now this is a question on tort. In negligence, chain of causation must remain intact. आपको पहले बताना है कि नेग्लिजेंस क्या होती है. There is a duty to take due care. Duty means legal duty, to take due care. And if it is not taken, it will amount to negligence. Right? So, in negligence, chain of causation must remain intact. What is the chain? What is the chain? Chain is, first there has to be a duty. then there has to be a breach of duty. And what duty? Legal duty to take due care. What the law expects you to follow, to take care. And by whom? By a reasonable, ordinary, prudent person. Not a person of very high caliber. These are the chain. This will form part of the chain. Describe the essentials of negligence. आ गया?
Yes.
And by referring to case laws, yes, we have Subhagwanti's case, we have other cases also. Town hall wala jo hai. ठीक है? Let's see this. Breach of a legal duty to take care which results in damage. So पहला क्या है? There has to be legal duty to take due care. There is a breach resulting in damage. This is the chain. Clear? Undesired by defendant. So ये है चेन आप. ये आपने बनानी है वहां पे. चाहे इसी फॉर्म में बनाओ या वैसे लिख दो एक के बाद एक. राइट? रीजनेबल मैन, ये जरूर लिखना है. रीजनेबल और प्रूडेंट. हाउ मच केयर हैज टू बी टेकन. राइट? ऑर्डिनरीली प्रूडेंट मैन. Person कह दो. Right? And then you have the third case of Subhagwanti clock tower case. Case लिखा हुआ है. Case laws, you will have to write this. Fine? Is it clear? देखिए, there is a straight question and straight answer. Where is the problem? Where is the difficulty? चलिए. See. Define atrocity. Also discuss the acts that amount to atrocity under the provisions of Scheduled Caste, Scheduled Tribe, Prevention of Atrocities Act. लॉ भी दे रहा है वो तो क्वेश्चन में आपको. और लॉ के सेक्शन 2A में आपका दिया भी हुआ है कि कौन कौन सी एट्रोसिटीज हैं. You start thinking of atrocities. What will amount to atrocity against SC/ST? Immediately you will come to this conclusion. He himself should not be a member. क्या? ये सारा. Obnoxious substance 1. Cause injury. Number 2, insult, annoyance by dumping excreta, waste matter, carcasses. There are so many of them. Try to just visualize. सारी याद करनी बड़ी मुश्किल है, but you can visualize क्या क्या हो सकता है. If words permit, you can start your answer with Article 17, abolition of untouchability. Untouchability stands abolished. The state shall make laws to ensure that untouchability is not practiced. This is what Article 17 says. It's a fundamental right. In pursuance of that, the Parliament has made this law. State, here I talk about Parliament, the legislature. The legislature, in conformity with the Article 17, has enacted this law. And under this law, Section 2A talks about atrocity. And atrocity is what? What should come to your, like the dictionary meaning of atrocity? अत्याचार. अत्याचार तो हिंदी में हो गया ना. तो you are doing something which is against the dignity of a person. Physical, mental, otherwise, reputation. किसी भी तरह से आप इंजुरी कर रहे हो उसको. और इंजुरी अंडर द लॉ इज व्हाट? Bodily, mental, property, reputation. All these will be covered. Right? So here, write it in this form. Start your answer with Article 17 leading to enactment of this law to prevent atrocities, because it is a specific law, prevention of atrocities against SC/ST. Specific law is there, and then what is defined as atrocity? Word atrocity means this, and it has been further defined and specified in section 2A of this act. क्या चाहिए आपको इसमें?
सर एक मेरा बेसिक सा डाउट सर जैसे सर झगड़े में सर कोई किसी का जाति का नाम लेके गाली दे देता है,
वो भी आएगा इसी में. That is also atrocity. इसमें सब चीज दे रखी है. Derogatory. Everything will come in this. Right? So you can just add this if you want. Otherwise, this is sufficient. Then comes question number 3A. Again 20 marks. 250 words. This question has to be tackled, and a few more questions like that. You have to be absolutely clear about the terms used, because you will have to first explain those terms. What is assault and what is use of criminal force? What is the difference between the two? Are they the same? They are different. An assault is by a gesture. You create an apprehension in the mind of the other person that some harm will be or he will be hurt. Is it clear? Assault में आप सिर्फ दिखावा दे रहे हो उसको. Use that the criminal force will be used against you, and that creates an apprehension that this person is going to use criminal force against me. This is one part. Second is criminal force, actual use of criminal force. Because if you see, to a woman with intent to outrage her modesty, immediately which section will come to your mind? 354, outraging the modesty of a woman. Right? But there's another term, sexual harassment, which has a wider meaning. Sexual harassment has been explained in POSH Act also, in IPC also. Sexual harassment has been, the definition has been given, the scope has been given. So sexual harassment can be a verbal thing also, can be showing a pornographic material also. Where is the criminal force or assault in that? है क्या? यही डिफरेंस आएगा दोनों में. When you talk of outraging the modesty, it will be either use or threat of using criminal force or assault, creating an apprehension in the mind of the victim. But in the case of sexual harassment, it may not be this, but it is given in different forms. It may be physical, it may be non-physical also. Passing of certain remarks, asking for sexual favors, right? That will come under. But if you remember KPS Gill, Rupandel Bajaj, there was actual use of, there was a physical assault. And that was covered under 354. Of course, at that time, there was no POSH Act. That came in 2013 only. But yes, to explain this outrage the modesty, you can give that example also. That illustration, not example, it's a wrong word. I apologize for that, but yes, you can cite that. Right? Let's see the answer. 354. So you have to explain these terms because you have the words. Then what is outraging the modesty? Then you come to 354. पहले ये explain करिए. That this, why it is taken as outraging the modesty? It is given in this case also. Modesty is the quality of being modest, and in relation to a woman, womanly propriety of behavior, scrupulous chastity of thought, speech and conduct. Yes, please. बताइए. हाँ जी बताइए.
सर सेक्सुअल हैरेसमेंट में कितना मतलब आईपीसी लगेगा?
कितना?
आईपीसी लगेगा मतलब कितना सेक्शन लगेगा?
अभी आ रहे हैं, 2 मिनट रुकिए, अभी आ रहे हैं, उसी पे आ रहे हैं, अभी खत्म नहीं हुआ, अभी इसका दूसरा पार्ट है. अभी तो मैं सिर्फ आपको बता रहा हूं आउटरेजिंग द मोडेस्टी वाली बात. राइट? सो फर्स्ट इज दिस. इसका मतलब इस केस में बड़ा क्लियरली दिया हुआ है. Why it is an offense? Why any such act against woman is taken as outraging her modesty? Now, ठीक है जी, देखिए सेक्शन 354A inserted by 2013 amendment defines the offences of sexual harassment. आ गया जी. In the following manner, physically contacts or advances involving unwelcome and explicit. इसमें unwelcome word बड़ा important है, पॉश एक्ट में भी दे रखा है. That means which is not liked by the woman. Somebody making a phone call, somebody sending a message, right? That itself, if she doesn't like it, somebody offers a woman to go out for a cup of tea, coffee. No, she refuses. That is unwelcome. Any advance towards her. Demands request for sexual favors, pornography, shows. आप कोई ऐसा मैसेज भेज रहे हैं जो जिसमें pornography है, it will amount to that. और shows ऐसे दिखा रहा है ताकि वो भी देखे. Make sexually colored remarks. So you can find the difference between this and this, isn't it? Is it clear now? So it has got a different meaning, whereas assault or criminal force with intent to outraging her modesty is working on a different platform. There is overlapping between the two, but that overlapping is not much because sexual harassment deals with many other things, not merely outraging the modesty. Right? Chaliye. Now we come to B part. Elaborate the reasons for what is e-commerce. यहाँ से पहले शुरू होगा आपका. In Consumer Protection Act of 2019, friends, it's a very recent act, particularly relating to e-commerce. What is e-commerce? Digital sale and purchase. Commerce क्या होता है? Trade and commerce. Sale purchase. Right? When sale purchase is done by digital media, it will become e-commerce, electronic commerce. और इसकी जरूरत क्यों पड़ी? Reasons आपको ये बताने हैं. So first define what is e-commerce, then what is the need for this. See, in the case of physical sale and purchase, you already have a Consumer Protection Act. इसकी जरूरत तब पड़ी when The trend is towards e-commerce. E-commerce is growing. Digital commerce is growing. And the buyer beware. Have you heard of this term? जो खरीद रहा है, he should be careful. But on e-commerce, on digital platform, there are certain things which are not clear to you. Sometimes something else is shown to you and you order it. And later on you find it is not the thing which I wanted to have. Right? So all these things have emerged with the changing. This is what you have to explain in your answer. ये 15 मार्क्स का 200 वर्ड्स में. So e-commerce has to be explained very carefully and in very simple terms. जो मैंने बोला है उसमें से वर्ड्स निकाल के you have to mention. Buying or selling of goods or services over digital or electronic network. Right? Then provide information about the goods and services being sold on e-platform. Return, refund, exchange, warranty, guarantee. What is the difference between warranty and guarantee?
सर वारंटी एक पीरियड ऑफ टाइम के लिए आता है, गारंटी में सर उसका जो सामान आता है उसका एक्सचेंज हो जाता है.
When the goods is replaced entirely, it is guarantee. Warranty is that it should be in the same form in which it was shown to you or the information was provided to you. The seller has to ensure that it remains in that form. कोई खराबी आ गई वो उसको ठीक करके दे देगा, पार्ट रिप्लेस कर देगा, पूरा प्रोडक्ट रिप्लेस नहीं करेगा अनलेस इट इज सो रिक्वायर्ड. राइट? गारंटी में है कि अगर आपका प्रोडक्ट आपको नहीं पसंद आता, खराब होता है तो वो रिप्लेस होगा. यस, हाँ जी, पूछिए.
पर सर अगर सेलर ठीक करके ना दे तो क्या कंज्यूमर कोर्ट में भी जा सकते हैं? बिल्कुल
जाएंगे. इसीलिए तो कंज्यूमर प्रोटेक्शन एक्ट किस लिए बनाया आपके लिए. इसी की तो बात हो रही है कि अगर वो नहीं करता है, इसी में वारंटी और गारंटी दोनों दे रखी है कि अगर उसने प्रॉमिस किया, आपको वारंटी दी है, एक वारंटी कार्ड मिलता है ना आपको, या वैसे ही आपका अगर डिजिटल प्लेटफॉर्म पे तो लिखा होगा वहां पे. इसीलिए ई कॉमर्स का एडिशन किया गया है इसमें कि आपको इंफॉर्मेशन मिले. द पर्सन हु वांट्स टू परचेज बाई the goods or services must have sufficient information on the digital platform, right? Necessary for enabling the consumer to make an informed decision at the pre-purchase stage. खरीदने से पहले, बाद में नहीं. हम कहते हैं ना कस्टमर, तो I sometimes call it कष्ट से मर, क्योंकि आपको इंफॉर्मेशन सही नहीं मिलेगी तो आपको तो कष्ट होगा ही. यहां ये सब पूरा नहीं किया जाता, तो रिप्लेस नहीं किया जाता या ठीक नहीं किया जाता, या जो उन्होंने बताया उससे मेल नहीं करता, अलग चीज है, अलग सर्विस है. राइट? चलिए. द न्यू एक्ट हैज बीन इंट्रोड्यूस्ड आफ्टर मेनी अमेंडमेंट्स टू प्रोवाइड प्रोटेक्शन टू बायर्स not only from traditional sellers but also from e-commerce retailers. अब सबसे बड़ा एग्जांपल आपके पास Amazon है, Flipkart है, there are many others. क्या है उसमें? When you search for a product, वहां मेरी बुक्स भी हैं भाई सारी, you can go through that. If you find any discrepancy, let me know. ठीक है? Some time back, some other fellow started selling the same books at a lesser price. वो खुद प्रिंट करके. I immediately sent a notice to Amazon. This is a violation of copyright. My trademark is already registered N BY IAS का. I have got a registered trademark, and he is violating the IPR laws. Amazon will be responsible. The next moment it was removed. So all my books are having that logo, that trademark, and you can distinguish, because trademark is a mark which distinguishes the goods or services of A from B, others. तो आप उसमें देखिए क्या इंफॉर्मेशन दी गई है, क्या इस बुक में वो क्वेश्चन आंसर दिए गए हैं, क्या उसमें लैंग्वेज ऐसी लिखी गई है जो क्लेम की जाती है. What is the replacement procedure if I don't like the book, can I, or if I receive it in torn condition or in bad condition, what is the remedy available to me? All this information should be on that platform, digital platform. Okay, chaliye. Penalty for non-compliance. If you remember, you can write, right? But you have to write this. Look at, मैंने पढ़ा नहीं था second part. Yes. Discuss the consequences for not complying with the provisions of the Act. वो ये है. Right? Here it is clearly given. चलिए.
सर 3A में मेरे को थोड़ा डाउट है सर.
किसमें?
3A में सर. जिसमें आउट
बाद में 3C पे आ गए हम, उसी टाइम पूछते आप, बाद में कर. Illustrate the essentials of private nuisance. This is a tort. Nuisance is a tort. But what is public nuisance and what is private nuisance? हमारे notes में exhaustively it has been covered. Also, और क्लास में तो अपने कराए हुआ है सेशंस में. Remedies available to plaintiff in a suit for, who is a plaintiff? Just for understanding. Who claims, who files the plaint. That's why it's called plaintiff. जो जिसके साथ wrong हुआ है, he approaches the court with a plaint, with a claim. He is plaintiff. Now, so first thing is you have to mention what is private nuisance. What are the essentials? How it is different from public? You may write or you may not write. एक single sentence में लिख सकते हैं, कोई इतना जरूरी नहीं है, but you cannot miss out on this essential. But differentiate करोगे थोड़ा सा तो clarity आ जाएगी आंसर में. As distinguished, इतना लिख दो बस. Affecting some particular individual or individuals. Then you have to write what is nuisance, the definition of nuisance. Causing annoyance, right? Or read the complete this thing, our notes. So what is, it's not only subject of indictment, but may also be a ground for civil action for damages or an injunction or both. What is the remedy available? We are coming to that. Remedies available to plaintiff. क्या होगा? Damages claim कर सकता है. Abatement of that nuisance. हटाना, उसको खत्म कर देना. But when you yourself, the plaintiff himself is abating the nuisance, he should not have any use of force, recourse to use of force, or take any violent or any other action himself on the defendant. But abatement is one remedy. Damages is another remedy. Injunction that this should be stopped, जिसको हम स्टे भी कहते हैं आम लैंग्वेज में. ठीक है. इंजंक्शन इज स्टॉपिंग दैट न्यूसेंस. सो लेट्स सी. ऑन tort of nuisance, following essentials are required: unreasonable interference, use of enjoyment of land, and damage. So what are the remedies? Abatement, which is removal of the nuisance, damages, injunction. Your answer is complete. ठीक है. चलिए. 4A. Again, 20 marks, 250 words. Friends, very important. I was telling you in 1986, there was a illustration when I wrote the exam, and whether any offense is made out, and the offense of theft was made out in that question, where in the case of criminal liability, what should be there? Both mens rea as well as actus reus. Each offense under IPC will have a clear mens rea or actus reus other than the strict liability offenses. Right? So here they are asking about, in this question, the opening of the question is dishonest intention is the gist of the offense of theft. When it says gist means what? अगर dishonest intention नहीं है, mens rea is missing, offense of theft will not be complete. So it is very much essential. So what is dishonest intention? Section 24 में देखिए क्या लिखा है. Dishonestly. When we say dishonestly, very right. Wrongful gain, wrongful loss. अब ये तो आपने लिखना ही है. अब आपको इसको भी एक्सप्लेन करना है. It is given in section 23 of IPC. What is wrongful gain? A gain to which a person is not legally entitled to. A wrongful loss, a loss to which a person is not legally entitled to lose, to incur that loss. ये लिखना है आपको अपने आंसर में. मैंने भी लिखा था, यही लिखा था, क्योंकि यहां तो बड़ा क्लियरली, वहां तो थेफ्ट का पूरा उन्होंने गैमेट पूछा हुआ था. All the 5 elements of section 378, dishonestly, movable property, out of possession, without consent, and moves. 5 to complete the offense of theft. यहां तो सिर्फ आपका मेंस रिया ही पूछ रहा है. So you have to explain this. Examine the above statement with the help of relevant illustrations. We can give any number. If dishonest intention is missing, there's no theft. If I take that property which is I am entitled to, and with the consent of that person, somebody gifts me something, where's the dishonest intention? Where's the wrongful gain, wrongful loss? Chaliye. Now, this is only first part of the answer. 250 words हैं, इसलिए बहुत बड़ा बनेगा आंसर इसका. But look at the second part. How theft is different from dishonest misappropriation of property. तो आप किस में जाएंगे? Criminal misappropriation. What is misappropriation? What makes it criminal? देखिए, एक्टस रियस क्या है और मेंस रिया क्या है. इन क्रिमिनल मिसअप्रोप्रिएशन, इफ समबडी फाइंड्स ए प्रॉपर्टी, मूवेबल प्रॉपर्टी, और कम्स इन पोजेशन ऑफ दैट प्रॉपर्टी एंड appropriates that property for his own use, for himself or for any other person. Theft में क्या है? That property is in possession of somebody. Here there is no possession. आपको मिल गई कहीं से. समझ रहे हैं? In theft, it has to be taken out of possession of somebody. यहां किसकी पोजेशन में? या तो आपको मिली है, सड़क किनारे आपको एक रिंग मिल गई, गोल्ड रिंग मिल गई, आपने उठा के, यू डोंट नो द ऑनर एंड यू हैव टेकन नो स्टेप्स टू फाइंड आउट, और आपने रिंग अपने पहनी और चले गए. यू हैव एप्रोप्रिएटेड. बट व्हाइल एप्रोप्रिएटिंग, व्हाट इज योर मेंटल कंडीशन? dishonest, wrongful gain, wrongful loss. So how it is different? How theft is different from dishonest misappropriation? This is the second part. चलिए देखते हैं. What are the essential ingredients? Dishonestly any movable property, out of possession, without consent, moving. 5 elements हैं, इसमें मैंने 3 में कर दिया. Now, you give this example. There are so many examples. A tree, when it is attached to the earth, is immovable. But when it is cut, the moment it is severed, the movement is there, moves. Moving properly. But what is required is this intention, dishonest intention. अगर उसने पेड़ काटा है डिसऑनेस्ट इंटेंशन के लिए, उसको पूरा करने के लिए, तब वो थेफ्ट बन जाएगा. राइट? इट इज देयर इन द इलस्ट्रेशंस आल्सो. सो व्हाट इज डिस्टिंक्शन बिटवीन दीज टू? Initial taking of property. First, in theft is always wrongful. In criminal misappropriation, it may be honest in the beginning. Later on, it may become dishonest. आपको एक प्रॉपर्टी मिली, पहले आपकी इच्छा नहीं थी उसको हड़पने की, appropriate करने की, but you can develop later on. But in theft, it is right there from the beginning. Invasion of possession of another person. In theft, there is. In criminal misappropriation, there is no invasion. It is not in possession of anybody. You just find it. Mere moving by itself is an offense in theft, but not necessarily. जैसे आपको मिली, criminal misappropriation नहीं हुआ. ये तब हुआ जब आपकी नीयत खराब हो गई, and you have appropriated that property. Right? Moving in property without consent. But where is the consent? In misappropriation, वह बंदा ही नहीं है, तो consent कहाँ से होगी? So this is your second part of the answer. Right? Dishonest intention is common to both. In fact, friends, if you see, and I always teach in great detail, in offenses, see, our syllabus is divided on law of crimes. Yes, there are certain definitions. Then you have offenses against human body, offenses against property, offenses against state, offenses against mental, your reputation. Defamation is there, right? So these are broadly divided. Mens rea also keeps on changing, but in the case of offenses against property, you will find there is a common thread of dishonesty, wrongful loss, wrongful gain. Right? So if it is there in all offenses against property, चाहे वो चीटिंग है, ठीक है, चाहे फोर्जरी फॉर द पर्पज ऑफ चीटिंग है, वहां fraudulently is also attacked, but I'll not talk about that now. Here, let us concentrate on this. So, dishonest intention is common to both. This is what you have to write in your answer to complete your answer. Now we come to 4B. What is this? 15 marks, 200 words. Examine the term undue advantage as defined under the Prevention of Corruption Act 1988. अब देखिए, here comes the real test of your knowledge. Prevention of Corruption Act was enacted in 1988. Previous one was in 1947 when that has been repealed and new act has come 1988. उसमें भी अमेंडमेंट, मेजर अमेंडमेंट हुई है 2018 में, मेजर अमेंडमेंट टू widen the scope of various terms under the Prevention of Corruption Act. I am an ex-CBI officer. मैंने 5 साल पीसी एक्ट में केसेस इन्वेस्टिगेट किए हुए हैं. So there is a specific offense of criminal misconduct. But what will amount to criminal misconduct? हम जैसे कहते हैं ना, मर्डर कर दिया, थेफ्ट हो गई, इसी तरह से क्रिमिनल मिसकंडक्ट का चार्ज लगता है अगेंस्ट व्हेन somebody is charged with corruption or what is given in the PC Act. Abettor, bribe giver, bribe taker. अब ये देखिए, first let us confine to this. They have not written the words bribe. They have not written the words corruption. They have written the words undue advantage. 7A of the amended part. 2018 की amendment बहुत important है. You can find them in our notes exhaustively, and it is taught in the class in the manner which I am now explaining to you. What is undue? So first we have to write this. So what is undue? Which is not due to anybody. Not due means not due legally. What law provides other than that. If I say remuneration, legal remuneration, क्या होता है? सैलरी है, कार है, घर है, अदर पर्क्स है जो लॉ के द्वारा आपको मिलते हैं एज ए पब्लिक सर्वेंट, राइट? एंड पब्लिक सर्वेंट इज ए वेरी वाइड टर्म. इट डजंट ओनली मीन गवर्नमेंट सर्वेंट. पब्लिक सर्वेंट की सेक्शन 21 आईपीसी में भी डेफिनेशन काफी बड़ी दी हुई है. अब उसमें बहुत कुछ आ जाते हैं, पीएसयूज के एम्प्लॉयज भी आ जाते हैं, कमिश्नर्स भी, देयर आर सो मेनी थिंग्स. आई एम नॉट गोइंग टू एक्सप्लेन. Let us concentrate on what is to be written in this answer. Undue is not, which is not due legally. Law permit नहीं करता. Anything which is other than legal remuneration, other than. Right? So, advantage. Undue advantage. एडवांटेज होता है एक, आप किसी का फायदा कर रहे हो. इट इज टू माई एडवांटेज. मेरे फायदे, मुझे फायदा उससे मिल रहा है. फायदा मॉनेटरी भी मिल सकता है और नॉन मॉनेटरी भी मिल सकता है. यू मे गेट मनी इन द फॉर्म ऑफ ब्राइब और what? You can get some property. You can even avail certain things like visit to some hill station, flight ticket, stay for you, for your family. They are all undue to you. They are not due legally.
प्रमोशन भी हो सकता है.
हाँ जी,
प्रमोशन भी हो सकता है.
प्रमोशन कैसे होगा?
जिससे ब्राइब वगैरह देके करवा देते.
ब्राइब देना अनड्यू एडवांटेज है. उस बंदे के लिए जो ले रहा है उसको एक अनड्यू एडवांटेज मिल रहा है. आपने पैसा दिया तो दैट इज अदर देन हिज लीगल रेम्यूनरेशन, वो अनड्यू एडवांटेज में आ जाएगा. सो ही इज टेकिंग अनड्यू एडवांटेज. इट कैन बी, इट्स अ वेरी वाइड टर्म. इट सिंपली डजंट कवर ओनली ब्राइब, इट कवर्स लॉट मेनी अदर थिंग्स, राइट? Section 7A does not use the term corruption or bribe, but uses the phrase undue advantage. Any benefit which is given to a public servant, this is advantage. It can be monetary. This should not be something other than public servants legal, should be something other than his legal remuneration. This is the key term. ये आपने अपने आंसर में जरूर लिखनी है, राइट? प्रिवेंशन ऑफ करप्शन एक्ट में अगर आप ये टर्म्स यूज नहीं करते, योर आंसर विल बी 0. आई एम टेलिंग यू वेरी क्लियरली. आपको बड़े ध्यान से पढ़ना है इसको. द वे आई एम टेलिंग यू, you have to write in the same manner. Then 17, अब आ जाते सेकंड पार्ट पे. पहला हो गया यहां तक. Also discuss the persons authorized and procedure required to be followed while investigating cases that are registered under this act. Who can investigate? There are 2 acts. One is a Delhi Special Police Establishment Act of 1946. It makes very clear an inspector of police and above in Central Bureau of Investigation, CBI. The CBI officers get their power from the DSP Act. They don't get power under PC Act. Please. They only enforce PC Act. अब इंस्पेक्टर हो गया. इन द केस ऑफ स्टेट पुलिस इट इज डिप्टी सुपरिटेंडेंट ऑफ पुलिस, और इन मेट्रोपॉलिटन एरियाज इट इज असिस्टेंट कमिश्नर ऑफ पुलिस एंड अबव. द मिनिमम रैंक इज दिस. लेट्स सी. By an officer not below the rank of inspector of police in CBI, in metropolitan areas, ACP. अब ये पूछ रहा है, इट इज बीइंग आस्क्ड इन द क्वेश्चन. यू हैव टू नो दिस, नहीं तो क्वेश्चन आंसर आप लिख नहीं पाओगे, राइट? देन प्रोसीजर. पर्सन्स ऑथोराइज्ड आ गया इसमें ये. अब प्रोसीजर, क्या प्रोसीजर है? नो ऑथोराइज्ड ऑफिसर कैन कंडक्ट इन्वेस्टिगेशंस or cause arrest without obtaining an order from the Metropolitan Magistrate or Judicial Magistrate First Class. There's another aspect to it, that the state government under Section 6 of DSP Act should have given the consent for the CBI to operate. Recently we have seen what? Some states have withdrawn their consent. Right? In that case, if it is a court-ordered investigation, then no consent is required. There is a general consent, there is a specific consent. General consent is that CBI can operate, can investigate any number of cases, any type of cases. Specific is only for this case, particular case. So, in the case of court-monitored, court-ordered investigation, it may be by CBI, it may be by any other investigating agency, the Section 6 consent will be there. If it is not there, it is not required in the case of court-ordered investigations and, operations. Second, 17A. No person can investigate an alleged offense when such offense deals with the recommendation decision taken by public servant in discharge of his official duties. When he is passing any orders or giving any directions in the discharge, or when he is acting as a public servant. In that case, only after approval of central or state government, as the case may be. But there is one exception to that. आपने सुना हुआ है, what are trap cases? Somebody is caught red-handed. Red-handed क्या होता है? It is a trap case. When person is caught taking bribe, वो रेड हैंडेड का एक मतलब होता है, आई विल नॉट टीच यू हियर, यू कैन रेफर टू माई वीडियो देयर. It's a प्रोसेस, फिनोफ्थलीन पाउडर लगाते हैं नोट्स पे, फिर सोडियम कार्बोनेट सोल्यूशन में उसके हाथ धुलवाते हैं, वो रेड पिंक हो जाता है, इसलिए वो कहते हैं रेड हैंडेड, राइट? सो इन ट्रैप केसेस this approval is not required. So you have to be very thorough with these procedures. क्वेश्चन पूरा पूछा गया भाई आपसे, नहीं आता होगा तो कैसे करेंगे, right? And these things are not taught in such manner, I can guarantee to you. Now, C. Critically analyze with the help of decided cases the essentials to be proved by a plaintiff in a suit. This is law of torts. What is malicious prosecution? Very important aspect. इसका जानना बहुत जरूरी है. In simple words, malicious comes from the word malice, ill will, malefied, bad intention, not in good faith. This is malicious. And what is prosecution? आपको ये लिखना है भाई वहां पे. When prosecution starts, when criminal proceedings start, please note down. It doesn't start with filing of FIR. It doesn't start with police investigation or an inquiry ordered by the court. The prosecution starts only when a charge sheet is laid before the competent court and court takes its cognizance. Charge sheet 173 CRPC में फाइल होती है. Court, then only the criminal proceedings will start. So anything before this is not prosecution. Starts with this. And if it is done with this, it becomes malicious prosecution. Are you समझ? Okay. Now we come to the points. The wrongful institution of criminal proceedings against someone without reasonable grounds. So we have to now first explain what is malicious prosecution with all these details, then what are the essentials, and with the help of decided cases. क्या है essentials? The plaintiff has to prove, number one, that he was prosecuted by the defendant. अब आप कहोगे प्रोसिक्यूशन कौन लॉन्च करता है? प्रोसिक्यूशन कैन बी लॉन्च्ड बाय ए कंप्लेनेंट or prosecution can be launched by the state in the case of criminal cases. But here we are talking about tortious liability. So it will be by a person, complainant. He files a false complaint and starts the judicial process in motion, puts judicial process in motion. Or in the case of criminal proceedings, the moment charge sheet is laid and court takes the cognizance of that. The prosecution was instituted without any reasonable probable cause. Defendant acted maliciously and not with mere intention of carrying the law into effect. The proceedings complained of terminated in favor of the plaintiff. That means what? The proceedings were proved to be wrong, malicious by the court itself. Right? The plaintiff suffered damage as a result of the prosecution. These are essentials of malicious prosecution. So give the case. You have this 2006 case also. Malicious prosecution is a judicial proceeding instituted by one person against another from wrongful or improper motive and without probable cause to sustain. It is malicious prosecution. Is it clear? This completes your answer. Fine. So thank you, friends. With this, we have completed section A of 2023 Law Optional Paper 2, which has been recently, in the last Sunday, it was asked. And in the next session, we will be taking up section B and completing the entire examination of law optional, of UPSC exam, Civil Services exam. Any questions? Anything? I again tell you, this is my way of not teaching or coaching, but guiding. And exactly this is what is reflected in the questions we have gone through in all the previous 2 sessions and today's sessions. Right? So, thank you very much, friends. We will kindly wait for the last section B of paper 2. Thank you.